It's just after 12:30. Welcome, everybody. I'm Neil Kalin, joined by Ashley Peterson and Frantz Farreau. We've got a really filled session today. So let me share my screen so everybody can see what we're going to be doing. All right. Everybody see it? Thumbs up, something? Okay, good. Thank you. Right. So here's our three hosts. Those of you who haven't joined us before, the real property section, we just host a monthly sort of Zoom session where we talk about current events in real property law. And what are we going to be talking about today? Well, here we go. We've got some cases we're going to talk about. Manella versus Stone, Yanez versus Vasquez, a little update on the CDC eviction moratorium, which will lead us right into our interview for today, and that's with Rachael Callahan, who knows all about evictions and how evictions are done and the problems with them these days. And then after Rachel's interview, and by the way, Rachael, you're there? Say hi to everybody, please.
Hi, everybody.
Hey, okay, great. Thanks, Rachael. And Rachael, you're welcome to join us in our discussion of the cases that we're talking about before and after the interview with you. Then we have another couple of cases, one talking about privacy versus nuisance, really topical given the use of Ring cameras, Nest cameras, all the security devices people have in their homes today. And then for the litigators, I'm not a litigator. I was thinking, boy, we really needed JR today. We needed a litigator to talk about some of these issues, but statutes of limitations and how important it is. We'll wrap up with letting you know what sort of MCLE events and other events are being put on by the real property section. As always, we welcome your suggestions, your comments, what you could do with us, and let's get right into it. We'll jump right into our first case of the day. And that is Manella versus Stone. Case decided just a couple 2 weeks ago, July 1st of this year. What happened in Manella versus Stone? Well, kind of an interesting case. You have a contractor who entered into a remodeling contract for a homeowner. Started work in February. The contractor decided he's going to create a business entity and run his contracting business through the business entity. So in March, the contractor Stone formed the entity JDDS. And what did he do? He assigned all of his rights and obligations to the entity. But at the time of the assignment in March, JDDS was not yet licensed under the contractor's licensing law. Okay, did not yet have the authority because Stone's individual license had not yet transferred to JDDS. Stone kept doing work on the property. We see, there's a big sum here, a big dollar amount. Ultimately, there was a dispute between Stone and the homeowner. It said the homeowner already paid, $2+ million on this property. I don't know where the property was. Don't know exactly what they were doing. Stone and the homeowner could not resolve the dispute. So what happened? Filed a mechanics lien and then pursued the mechanics lien. And the homeowner said, well, wait a minute, I'm bringing a motion to remove the mechanics lien because under the contractor's licensing laws, you cannot be paid, right? And the reason that the homeowner was saying that the mechanics lien was unenforceable, that the contractor could not be paid because under the Business and Professions Code, what happens, a person is prohibited from collecting for licensed work. And this is in the trial decision part of the page, a part of the screen. Cannot collect for licensed work if they were not licensed at all time during the performance of the acts under the contract. Like I say, in March, when the assignment was made, the entity was not yet licensed, got the license in June. Okay, but the collection effort was for all of this work that was done, starting with the work in February, actually. So what happens? The trial court said, yeah, well, wait a minute, there was an assignment, sorry, JDDS, you're out of luck. You cannot enforce the mechanics lien because if you did so, that would violate the B&P contract. The contractor appealed the decision. What did the appellate court say? The appellate court had a couple of interesting things to say. I thought, first of all, they start off with, in footnote 2, an assignment is an assignment of rights, not obligations, okay? In order for the obligations to be assignable, you need to have consent of the other party. There was consent of the other party that they're reading into the actions that happened after there was the actual transfer in June when the entity was licensed. Something else that I thought was kind of relevant here, which is what kind of contracts are assignable? Well, all contracts are assignable, except if the contract is for personal services. Well, a contractor's contract is for personal services. You're hiring that individual to perform the work. What the appellate court wound up saying was that the trial court was wrong, that the assignment itself, okay, did not mean that the work was being done by the entity as an unlicensed entity. They said until Stone, who was the original contractor, until his personal license transferred to the entity JDDS, that all of the work that was done by Stone was done under his individual license. And so the assignment in itself did not create the transfer of the obligation. All of the work was done by Stone until his license transferred to the entity. And then the entity, of course, was licensed at that point in time. So I thought kind of an interesting case. Real estate, a lot of work being done. A lot of, especially nowadays, a lot of work is being done. A lot of people are improving their properties. They're not moving. A lot of people are improving their properties. And this case and its issues might be relevant to those. Any comments, Ashley or Frantz?
Yeah, I mean, that's probably fairly similar to what it would be if like a real estate agent or broker lost their license, right, Neil, in the middle of like a sale or something?
Yeah, if they took a individual broker's license and then were transferring to a corporate broker's license, I think you could probably apply the same type of theory to that case, correct?
Yeah.
Frantz, what are you seeing? Are you seeing, like I say, I'm hearing that there's an awful lot of improvement going on, in spite of the rising lumber prices and everything else. What are you hearing out in the industry?
I am definitely hearing that there are a lot of home improvement projects, and I actually was involved in a case with a similar, not exactly a similar situation, but a situation where there were like multiple licenses and contractors asking for things that they weren't entitled to. And one of the things that I found interesting about this case when I was looking at it was just kind of how the appellate court was like, okay, there are procedural requirements and you should follow those, but you're not lawyers, and so we're going to kind of figure out a way of framing this so that technically it's going to be in compliance with the law because these are really onerous technical requirements. So I thought that was kind of a nice way for the appellate court to kind of just be like, yeah, you did it wrong, but here's a way it can be done so that you don't lose out on all the money.
So they got the right, what they thought was the right result.
Right.
Frantz, and you're thinking they might have had to fudge a little bit to get that right result, but it was still justifiable the way the opinion was written. So it's hard to argue with the opinion. Some may take issue with it, but there is support for the opinion. Matter of fact, the appellate court found a very similar type case, as good precedent for their finding. But I can understand what you're saying, which is, wow, this is really, maybe there was a technical violation. So if you're going to rely on the technical violation, the court said, well, then we're going to rely on the technicality the other way too, which is none of the work was done by the entity. The work was all done by the individual under the individual's personal license until the transfer actually took place. So if you're going to be picky one way, you can be picky the other way as well. I think there's a good reminder here. There's still a substantive dispute between the homeowner and the contractor as to whether the work was done properly. And the court was not going into the substance of whether the work was properly done. They're just focusing on the issue, was there a violation of the licensing law? Because if the court found there was a violation of the licensing law, boom, end of story, right? Neither the individual contractor nor the entity would be entitled to compensation whatsoever. So, yeah, go ahead.
Oh, no, I said, yeah. And I was going to say the one thing that I think, I guess from like less of a lawyer perspective and a little bit more of a law student perspective, is really understanding what issue the trial or the appellate court is dealing with. Because I think that even as lawyers, sometimes we or I kind of think that, okay, the issue that the appellate court is opining on is sort of the substantive issue. And we kind of forget that, no, they might be ruling on some very narrow technical issue, and the substantive issue has not actually been decided yet. So I think it's important when we're reading cases to remember that, what is the trial court actually opining on, and how can we use that opinion for our clients?
I think that's very relevant too. Something I didn't mention before, I'm just going to briefly mention it now in the appellate decision portion of the slide. The homeowner said, well, wait a minute. At the time of the assignment, JDDS was not licensed. The appellate court said that's the equivalent of simply entering into a contract, but not actually doing the work. And there's no problem with entering into a contract. The homeowner said, well, wait a minute, that is a violation of the licensing law. And they cited to 7028. And so the appellate court said, well, yes, that's a violation of the licensing law, but it's not a violation that prohibits the contractor from getting paid. It may subject the contractor to discipline from the contractor state license law, but we're focused on a different section of the law, and that was 7031. So there was a little distinction that was made there as well. So thank you too for your comments. Let's move on to our next case. And this is an unlawful detainer case as we're setting up for our discussion with Rachael. And in this case, you'll see it's a appellate division of the LA Superior Court. So just a little reminder, everybody, it is only binding on courts in LA County. Most regular appellate cases are binding anywhere throughout the state. An appellate division of a superior court case is only binding in the county of that superior court. So why do I bring it up? I bring it up because the issue is one that we find is common throughout the state of California. And while this case is focusing on the Los Angeles Rent Stabilization Ordinance, LARSO, right? In many areas of the state where we have this exact same problem, which was an illegal conversion of a garage to a dwelling unit. What happens if there's some violation of the lease, whether it's a written lease or in this case, it was a verbal rental agreement? What happens if there's a violation of that? And we see illegal conversions up and down the state. A lot of those areas, a good example is San Francisco. They have their own rent stabilization ordinance. So one would have to, I don't know if the court's reasoning here would apply to those other jurisdictions. But what happens with LA Superior Court when the appellate division, the appellate division of the LA Superior Court will generally only decide to publish a decision when they are finding that the courts are essentially being flooded with this particular issue. And they want to set a precedent so that there can be uniformity in decisions, at least through that court, right? And so my guess is if LA is having this issue, so are probably other jurisdictions throughout the state of California. Maybe they have their own appellate division precedents already, but maybe not, and they might look to this one. So real quickly, what happened here? You have a landlord illegally converted a garage to a dwelling unit, rented out to a tenant for $1,000 a month. The tenant made some improvements to the property. I couldn't really figure out what those improvements were. The landlord said, well, wait a minute, you're not allowed to make improvements to the property. That's a violation of our agreement. let my repair person in there to fix whatever it is that you did. The tenant says, no, I'm not letting anybody in. So what did the landlord do? The landlord brought an eviction action, an unlawful detainer action, based on a perform, covenant, or quit. What did the tenant raise the defense? The tenant says, well, this is an illegal unit under the LA rent stabilization ordinance. You cannot evict me for this reason. And whether it was non-payment of rent, whether it was a violation of the terms of lease, it does not matter, right? You cannot use my breach to evict me when you've rented out an illegal unit to me in the first place. Okay. What did the trial court say? They say, well, illegal unit, the lease itself is void and unenforceable, cannot support a UD action for failure to comply with the terms of the lease. Kind of some, I put down the language of the Los Angeles ordinance that you have there, that the court was able to look to. I kind of like the last sentence there. LAMC, and it gives a section number, allows for recovery of possession of rental units where the tenant has violated a lawful obligation or covenant of the tenancy, right? So the court could be saying, there's no lawful obligation here because landlord, you're renting out an illegal unit. The appellate division upheld the original decision. Some of you may be thinking, well, wait a minute. So if I have an illegal unit, I'm renting it out. So now the tenant says, I'm not going to pay or I'm going to violate the lease. You can't evict me. Ha, 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 ha. I'm just going to stay here forever for free. That's not true under the LA Municipal Code. Matter of fact, the case talks about how there is a procedure for a landlord to actually evict a tenant of an illegal unit if the landlord is going to bring the unit into compliance. Okay. And a landlord who does that has to pay relocation fees to the tenant, right? So there's a cost when you're renting out an illegal unit. And again, I think this is an issue that is probably happening throughout the state. Either of you two have something to say about that?
I think Rachel and I have talked about this before. I'd be interested to know Rachel's thoughts, but I know she's handled some evictions with like storage units that people were living in and like, pods and things like that are the most unlivable circumstances, but people are there, right, Rachel?
Oh yeah, and actually it brings us to the San Diego Ordinance that just recently passed, which extended the definition of a tenant to include people living in storage pods, garages, etc. And so it would be interesting to see how that plays out. We've seen it historically with regard to rents, where tenants will say, I don't have to pay rent because this is an illegal unit. And what we always tell clients is, let's get them out first, and then you can duke that out in small claims. But certainly they are tenants of some sort. They are occupants of some sort. Everybody has rights, but it's a problem if you're renting out an illegal unit. We tell clients not to do it. We usually terminate the tenancy without seeking any kind of rents. We certainly would not do a cure breach because there's nothing to cure breach because there's no valid contract. So although both parties still have rights, it's a problem.
I imagine that this is going to be a bigger issue. One thing that came up for me kind of listening to this is, there are some obvious clear cases where it's just an illegal unit, right? So like if it's a storage pod, you can't live there, right? Yeah. But what about places, where more than 50% of the house has been remodeled and it's not in compliance with code sections, so it's technically illegal, but it's still a house, right? And I see sort of on the brokerage side, a lot of houses that have like illegal additions or additions that are not in compliance or additions that have to be removed, or, people who have taken a shed and then turned it into an ADU and they're renting that out. And so like, what is that? How would this case sort of decide on these like partially illegal units and evictions?
And so I'm looking at the case and I'm saying, well, so much of it is dependent on the way the local law is written, right? So this case was focused on what the Los Angeles Municipal Code allowed to be done in this particular circumstance. So what if you're in an area, like you say, Frantz, where you have an illegal construction, but there is no local rent stabilization ordinance, right? Could one look at this case? I don't know. I don't know that, again, we know it's not binding outside of LA County, but is it influential? Well, I don't know if it would be that influential if there is no rent stabilization ordinance or something similar at all. I'm not really sure.
Right.
So, okay. So anyways, we just wanted to make you aware of what's going on in the industry. And now we're really going to lead into Rachel's interview. And just a real quick update. We've talked about the Center for Disease Control, CDC, the federal eviction moratorium. We've mentioned some issues here on What's Up before. And one of these cases made it all the way to the United States Supreme Court. And it was the Alabama Association of Realtors, technical name, versus Department of Health and Human Services. And so the Alabama Association, along with other plaintiffs, brought an action to have the eviction moratorium declared invalid. They were successful at the trial level. There was a stay put. So the trial court said, CDC, you're exceeding your statutory authority by entering into a national eviction moratorium, right? So then CDC appealed. The appellate court said, well, we're going to stay the trial court's ruling. Eventually made its way up to the US Supreme Court, okay? And we're going to find out what happened there. But before it made it, before the US Supreme Court was hearing the case, what happened? Well, the CDC, the eviction moratorium was set to expire July 31st, and I believe it was on June 24th. So it was set to expire on June 30th. On June 24th, the CDC says, you know, we're going to extend it for one more month. So the federal eviction moratorium through the end of July. Notice here in that box there, it says, this was on the CDC's website, this is intended to be the final extension of this moratorium. So I thought that was really kind of cute, because you look on the left side of your screen and what do you say? Well, the CDC's federal eviction moratorium, right, started in December, went through December. Then it was extended once through the end of January. Then right before that extension was about to expire, they extended again through the end of March. And then right before that extension was about to expire, they extended it again through the end of June. And now we have this latest extension that says, no, really, we mean it this time. This is the final extension of the eviction moratorium. Here's what the Supreme Court said when it got this case, right? There was an application to vacate the stay. The US Supreme Court denied the application, but probably what's most relevant here about the denial is that 4 justices said they would have granted the application, probably a good indication that they did not agree with the decision. And then Justice Kavanaugh wrote a concurring opinion. And look at that first paragraph. I agree with the district court that the applicants that the Center for Disease Control and Prevention exceeded its statutory authority by issuing a nationwide eviction moratorium. And down towards the bottom, in my view, clear and specific congressional authority via legislation would be necessary for the CDC to extend the moratorium past July. So here you have fifth justice who basically said, yeah, CDC, you were wrong. But if you look in the middle of that part of the screen, what does Justice Kavanaugh say? He goes, well, it's only going through July 31st. So, let's just let it go on for another month, right? But pretty good indication that they better not let it go, which may be why the CDC on their website says, no, we really mean it this time. This is the last extension of the federal eviction moratorium. Look on the left side of your screen, you see a little sort of orange box there. It's talking about the eviction moratorium. The order does not apply in any state, local, area with the moratorium, basically with their own moratorium on evictions. And that's going to lead us right into Rachel's interview, talking about the California extension of the eviction moratorium. And I believe she's also going to talk about the impact at the more local level at San Diego that has adopted a very restrictive moratorium on its own. So I'm going to switch the slide and let us get right into the Rachael Callahan interview. Take it away, Ashley.
Thanks, Neil. I mean, I think that's probably what's so frustrating for those applicants is that, by the time these cases get heard, a lot of these statutes are either going to expire or close to expiring. So then the court's like, well, it's going to be moot by the time we decide anyway. So, we're not going to make a decision on it. So that's just an aside, but I can see how frustrating that would be in light of all these constant changes that have been happening in these laws.
Before you get to Rachael, Ashley, it's frustrating for lawyers as well, right? Because you want to have some precedent so that if something happens in the future, you have some guidance. But it seems like the guidance now is, well, if it's going to take long enough to get to court, we're not going to bother with it,
Right.
which is really no guidance at all.
Right, I agree. It's too bad they can't make a decision on some of those things and whether they were truly unconstitutional or not, and so forth. I mean, they have their opinions in the readings, but yeah, it's not actually a binding ruling.
Right.
All right. Well, I am going to do the fun part of this part today by interviewing Rachael Callahan, who is a friend of mine and a colleague who I've worked with for several years now in the real estate world, and who I believe is the eviction guru in San Diego County. So Rachael, welcome. Thanks for being here. And why don't you give us kind of a little bit about your background and what you do, and we can go from there.
Thank you, Ashley, and it's a pleasure to be here. As far as my background, I've been practicing for a little over a decade, doing majority landlord-tenant real estate law. When you ask what I do, that answer varies from when you ask me. If you would ask me a year ago, I would say that my primary focus is helping owners and landlords regain possession of their property. Right now, I question every day what it is I do. We don't really have a whole lot that we can do right now. To Neil's point, as far as giving advice to people, I mean, that certainly has changed. Like you said, we'd love to have straight answers to give people. So what I do right now is I just try to keep my clients and interested parties updated on current laws, and hope that everybody can just hang in there until we could start doing what I usually do, which is help restore owners to their properties.
Well, and that's a full-time job in and of itself, staying on top of what these laws are. I can tell you, I have one property management client that operates throughout the state of California, and I'm literally pulling my hair out trying to figure out what to advise them on. I can't even imagine you with all your clients and staying on top of all this.
I was kind of laughing when Neil was talking about the CDC and saying that leads us to Rachael. And I'm like, please don't ask me about the CDC. I'm focused on California only at this point. But yeah, it's definitely been a challenge to keep up.
Yeah. So why don't you, I mean, most people are probably here wanting to know what's happening with the status of eviction in California. So why don't you kind of give us an update on AB 832?
Sure. So again, kind of parlaying into what Neil said, all of these wonderful new laws are being passed at the 11th hour. And so at the 11th hour this time, SB 91, which was supposed to expire June 30th, warped into or morphed into the AB 832, which is what you just mentioned. That's supposedly an extension on the SB 91. It does have some more restrictions, but essentially what everybody wants to know is, when does that end and when do we move on? The end date scheduled for the new AB 832 is September 30th. Ideally, come October 1st, we're back to normal. I don't see that as happening, but that's the deadline there. Now, within the AB 832, there are some additional requirements with regard to owners and landlords applying for rental assistance themselves. There are some more extensive restrictions on when and who you and how you can file an unlawful detainer. If you have anything specific that you're curious about, then I'm happy to answer. But the big deal is by July 31st, there's a new deadline to send out a brand new notification to any tenant who currently owes rent That notification does inform the tenants of their rights to apply for statewide assistance. It also actually informs landlords of their rights to apply as well. For qualified tenants, the state of California is offering to pay 100% of any rents owed, covering a period of March 1st, 2020 through, I suppose, September 30th, 2021. For unqualified tenants, meaning if tenants are making more than the medium average income, then the state of California will assist with paying the 25%. So there are a lot of good things about the extension. There are a lot of frustrating things about it. Of course, owners who have been without rents for 16 months are frustrated by the extension, but I can tell you from personal experience with my clients, the funds are coming in. So it overall seems to be some good news, and it does give people a little bit of a silver lining with regard to getting those rents, and then also hopefully an end to what appears to be a almost indefinite eviction moratorium.
So Rachel, I have a question for you.
Go ahead, Neil, sorry.
Yeah, so I have heard about some landlords who are basically taking a wait and see attitude during the last little more than a year. And now that the state of California said for qualified tenants, we're going to give 100% of back due rent, in some cases utilities, and in some cases future rent through the end of the COVID time period, so through the end of September. Can you think of a reason why a landlord would not go through the tenant rental assistance program at this point in time?
It would be foolish to do so, because there are arguments to be made, and in fact, pretty good arguments to be made, that if a landlord does refuse the rental assistance, then the landlord is in effect waiving their rights. More importantly, under the AB 832, now in order for a landlord to ultimately move forward, if, for example, their tenant does not pay what is required, the landlord actually has to show an affirmative rejection from the rental assistance programs. This entire time, I have been shocked by owners that have refused to participate. I've received excuses like, I don't want to give a W-9. Now, I don't give tax advice, but my response is always, well, aren't you claiming all of your rental income like you should be? Just kidding. The other excuse I get is, I don't want the government to help. I don't want government funds. That's, for lack of a better term, that's some liberal socialism, whatever. But at this point, if I have a client that says, I am not going to participate in the rental assistance program, my response is, I am not going to help or assist you, because what you're doing effectively is waiving your rights. You're also, in a more practical matter, waiving assistance to your tenants, which at this point I'm sure is well needed. There may be some tenants taking advantage, but at the end of the day, that money is there to help both the tenant and the landlord. And I see no good reason to not participate in the program. And in fact, to the contrary, it would be detrimental to preserving your rights to those rents to not participate in the program.
So how can landlords recover rent other than through the rental assistance program?
Wait, but the rental assistance program is the easy way to do it. The AB 832 has extended the deadlines and the time frame for when you can pursue regular rents. Come October 1st, regular rents should be due in due course, as they were before. If they don't pay, you can do your eviction. You can include past due rents. Now, as far as rents that have been owed since the beginning of the pandemic, specifically March 1, 2020 through ideally September 30th, those monies can be recovered through small claims. Previously, small claims, of course, would have a cap on the amount that you could request. That cap for COVID rental expenses, including utilities, rent, etc., has been lifted. Now, the caveat to that is that the owners must wait until November 1st in order to pursue that lawsuit. And so the recovery becomes what's called a consumer judgment, which means to anybody who's owed the rent, you can't evict based on it, but you can seek a judgment for it. Again, you have to wait till November 1st, and the idea would be to apply for that through small claims. It costs less for filing. There are no restrictions on the total amount, and you don't have to get lawyers involved So that would be the way to do it, is to obtain that consumer's judgment through the small claims once it's legal to do so. Of course, there's always the question of collections, but that would be the first step would be to get that consumer judgment.
So for filing small claims suits, the understanding is that you would still have to show proof that you tried to apply for the government assistance before you can go that route. Is that right?
That would be the assumption. And again, there are good arguments to be made and good evidence that leads us to believe that if you do not apply for that rental assistance, you have waived those rights. Just like if you do not supply to your tenant by July 31st, the California notice to tenant informing your tenant of these programs, then you could have effectively waived those rights.
Great. Okay.
So Rachel, I just want to remind everybody something that you said, that I know from talking with people in my business, I found people get confused about. That they think it's AB 832 extended the eviction moratorium through the end of September, but you do not have the right to file in small claims court until November 1st. So there is that 1 month kind of gap, that leeway period of time. So on October 1st, you can't say, even if you applied for rental assistance and was denied because maybe the tenant makes over 80% of the median income for the particular geographic area, you cannot go down to your small claims court on October 1st. You still have to wait until November 1st before you're allowed to file in small claims court, correct?
That's correct, which also brings up another practical point, which is by then you may have people who have tenants who have moved out, et cetera, and everybody needs to remember that once you can get to small claims and you can file that lawsuit that will probably not have a very high collective rate anyway if you receive a judgment, you have to find the tenant. And so if they're not still living in your property, that does present a new challenge.
So how does the state moratorium kind of play with regards to city or county ordinances, Rachel?
Yeah, San Diego County decided recently to pass, as Neil called it, a very restrictive eviction moratorium. The moratorium in San Diego does say, hey, we're not going to mess with anything that the state's doing. From a practical standpoint, the San Diego County moratorium covers a lot more than the state. The state does have restrictions on when you can issue 60 days for just cause. It also has restrictions on filing for rent. The county moratorium is even more specific and only allows us to move forward if there is an imminent threat to public health and safety by the tenant, created by the tenant at the property, affecting other tenants at the property, which the only thing I can really think of would be somebody sitting in their apartment in a multi-unit complex, lighting a fire in their living room. Now, I'd like to speak from a practical standpoint because really, at the end of the day, your question is, when can we move forward with evictions? San Diego County moratorium is supposed to last 60 days past the stay-home orders. Arguably, the extension of SB 91 in this AB 832, which is the statewide eviction moratorium, that could be construed as a stay-at-home order. So whether the San Diego one lifts or not is yet to be seen. The Legal Aid Society of San Diego has taken the position that the San Diego County ordinance will lift on August 15th. But again, to Neil's point, does that mean on August 15th, we can all rush to the courthouse? No, because the state of California has a moratorium that's going to go through September 30th. Again, practically speaking, County of San Diego, in my opinion, would likely match up the expiration with the statewide moratorium. And in my opinion as well, the state will likely extend our moratorium one more time to the end of the year. But yeah, it plays into it. And the San Diego County, and there's a couple other counties that have restrictive moratoriums. I know San Francisco does as well. It's not supposed to conflict with state law, but at the end of the day, it's easy to get around because state law says, okay, you can't evict for non-payment of rent. State law says you have to have very specific reasons for a 60-day. The local ordinance says if you do anything to try to get anybody to leave, you're in violation. So your owners and landlords in a local place that has an ordinance like that, they're not going to pursue anything, even rent-based evictions, with the fear of running afoul of the local ordinance. And again, everybody keeps mentioning what we do when things are temporary and they're about to run out. I don't know that anybody will challenge it effectively because I think the wait and see method is probably most economical for most owners. And so that's kind of where we're at now.
Yeah, it's really been a struggle to stay on top of it. Like you said, with city and county laws changing so frequently and with everybody being different. It's not like there's one uniform rule that's been applied all across the, the state of California. It's literally every city and county can do what they want. Everyone's just slightly different from the other one. It's like this one will allow A, B, and C, but this one's only going to allow C plus D. And it's like, it's just so I don't even know how you can even keep track to move forward with any evictions at this point in time.
And as we've seen as well, even if we're in full compliance to what we believe we understand the rules to be, there are other factors to consider as well. For example, San Diego County sheriffs for several months were not performing lockouts. And so even though possibly under local laws and possibly even under state laws and possibly even under federal laws, certain matters could proceed to lockout, the county sheriffs just weren't doing it. And so the wait and see may be an only option for some at this point. And hopefully we do have a light at the end of the tunnel. It's not that I'm in a hurry to start making people homeless, but I am in a hurry to try to be able to help my clients again. And I think that owners and landlords are fatigued as well with what they can do.
Yeah.
So I actually I have a quick question. I mean, we talk a lot about sort of eviction moratoriums as sort of applying to landlord-tenant relationships, which typically they do. But if you have like a foreclosure action, and like it's successful, I know there's another foreclosure moratorium, but how are these ordinances affecting sort of like the ability to lock out or get rid of somebody who's in a foreclosed home?
Sure, that's a great question. And prior to San Diego County's local ordinance, both the Center of Disease Control moratorium and the California statewide moratorium did not prohibit evictions based on foreclosure. And so prior to, at least in San Diego County, prior to the new ordinance, we actually were moving forward with those evictions. And the reason for that is because prior owners in a foreclosed property historically have not been considered tenants. Now, if there was a tenant in there that maybe had been under a lease agreement, then you have a different situation. But because the foreclosure laws are under 1161 A, that's a different statute than your regular eviction, 1161 subsection 3 and 4. And so we have been able to move forward with those, except for if your locality prevents it. Now, again, I mentioned that the sheriff's department in San Diego wasn't really doing lockouts for anybody, so they weren't really distinguishing upon the reason. But for the fact that a prior owner in a foreclosure is not considered a tenant, there have not been restrictions. Now, the CDC and some other laws have prohibited the actual foreclosure sales in certain circumstances. But if the sale happened, then we were able to, we were able to get it at least to lockout.
Okay, well, Rachel, this is great information. We've got a couple more cases. We want to let everybody know what's coming up through the real property section. Matter of fact, one of the items that's be coming up directly involves you, where instead of having 15 minutes, you'll have a whole hour to explain this kind of stuff. So if you don't mind, we're going to move on. Is that okay?
Oh, absolutely. I appreciate your time. This has been fascinating for me as well.
Okay.
Thanks, Rachel. We really appreciate it. And we're like Neil said, we're going to plug a free seminar that Rachel has coming up in the next 2 weeks. So stay tuned for that in just a few minutes.
Thank you.
Okay, great. Thanks a lot. We really appreciate you joining us today, Rachel. So we just have a couple more cases. Just want to bring to your attention. Again, we try to do things that are recent, things that we think are interesting, cases that we think are relevant to maybe your life as a real estate lawyer, or even your life just as a person living in the state of California. So here we have a case, Mesger versus Bick, made even a little more salacious because it involves a celebrity. So everybody loves a good celebrity story in their case. And it's basically, it's a neighbor problem case, right? I don't know. Maybe the only thing, more bitter than a divorce is a neighbor dispute, right? So, and here you've got something just like that. we have the Mesgers who had problems with their neighbors. That's the comedian Kathleen Griffin and her friend Bick. And Griffin and Bick complained about the Mesgers' loud parties and noise that was constantly going on. Interesting when you read like the Mesgers' viewpoint, it's like, we have a pool, we have kids, of course, there's going to be loud noise, from time to time. What do you want? We're allowed to live our lives. So at one of the times, the Griffin and Bick called the police to the Metzgers, or the plaintiffs, to their home in response to a complaint. And while the police were there, the police mentioned, hey, guess what, Metzgers? Your neighbors, they have a recording of what's going on in your house. Well, maybe that just like tipped the scale of an already bitter relationship between these two neighbors. And so the Metzgers said, we're not going to have any of that. They filed a lawsuit for nuisance, violation of the Penal Code 632, invasion of common law right of privacy, invasion of the California constitutional right of privacy, all this kind of stuff. Saying that basically the recordings, video, which had an audio component to them, violated their rights. The defendants, they moved for summary judgment. The trial court said, well, we've looked at what was done here, and yes, Griffin and Bick, they have a security system set up, but the security system is focused on their property, on their house, on stairways, leading up to their balcony. And there might be some incidental video that's being made of the neighbor's property. And yes, the video picks up sound from the neighbor's property, but that really isn't what they were doing. And just think about your own home. I mean, I go down, my neighbor has a Ring doorbell, right? Our two houses face one another. The entranceway to our two houses face one another. So I'm sure they're seeing everybody who's coming into my property, me, my family, my guests, whatever. But is that really the neighbor's intent when they installed their Ring doorbell? No, they want to see who's coming into their house, and everything else is probably just incidental, or at least I'm hoping that it's incidental with regard to my particular neighbor. So the trial court said, any privacy intrusion was really insubstantial, and they granted the motion for summary judgment. The appellate court wound up affirming. It was kind of an interesting appellate decision because most of the decision was focusing on factual issues that were read into the record at the trial level, right? Most of these appellate decisions, a lot of law, a lot of comparing cases and precedent. There was so much factual matter going on in this particular case. I thought it was kind of an interesting approach to the appellate decision. One of my favorite things about this, when I have there under the law, the various, theories that were being proposed. And one of my favorite things is the constitutional right to privacy, and not so much the right to privacy, but I don't know how many of you, have recently read through the California Constitution. Everyone probably all remembers, from basic civics class, the federal, right to life, liberty, and the pursuit of happiness. Well, do you know in California, you actually have a right to happiness, not just to pursue happiness. You have the right to obtain happiness. So I'm wondering who I can bring a claim against of all these times where I have not been happy in my life. I have not obtained happiness, and that's a violation of the California Constitution. I just don't know if I could do anything about it, but I thought I would include that in there. Section 1 of the California Constitution. I had a couple of other provisions there as well. What say you, Frantz and Ashley?
Is that what you're reading before bed, Neil? The California Constitution? I think that would certainly put me to sleep.
But would it make you happy? That's the issue.
No.
I thought the factual element was really kind of interesting. And I mean, I wonder sort of, there's like this reasonable expectation of privacy. So it's like, okay, yes, you have a reasonable expectation of privacy. If you're in your own bedroom or you're in a bathroom or something, you have a reasonable expectation of privacy. But it's like, how loud does your voice have to be that you have to reasonably expect that other people are not going to hear it, or that other people are going to hear it? And are courts the right places to make those decisions?
Well, that's why neighbor disputes are really hard to fight, because I get client calls all the time. They're like, oh, my neighbor is, cutting down things from my property. The neighbor's being noisy. The neighbor's yelling insults to me when I walk up to my door. And it's like, there's not a lot that person can do to really fight with a neighbor that's bad. I mean, you're just stuck with a bad neighbor, and now you have to disclose that if you go to sell the property. But it's like, you can't stop crazy, unfortunately. And like, clients ask me, they're like, what can I do legally? I'm like, you can try calling the police, but there's really nothing that they're going to do. I mean, they're on their property. They have a right to free speech. You can't stop crazy legally. Sorry, so.
And for the crazies, you can't complain when you're yelling that your neighbor can hear you yell, right? Yeah, I mean, that, it goes both ways. For those who like, the salacious stuff, during the factual portion of the appellate decision, there's a whole section that's completely profanity laced. And of course, it's all kind of blocked out, but you could probably figure out the words. I trust our audience is smart enough to do that. Okay, so let's go on. We got one more case here. Just I thought it was worth a mention. I know I'm in the residential real estate arena. Frantz certainly is too. Ashley, I know you touch upon that. I'm not a litigator. This is a case where there was a fraud claim filed by a homeowner who purchased a property from somebody who flipped it, somebody who bought it, fixed it up, flipped it, made improvements to it, and then sold it, made the improvements with somebody who was not a licensed contractor, did not disclose the previous problems with the house, did not disclose that the person who made the improvements was not licensed, right? Ultimately, there was obviously continuing problems with the house. The purchaser brought a lawsuit for fraud, negligence, breach of contract, a whole litany of causes of action. The statute of limitations for fraud is what? Is 3 years, and 3 years from date of discovery, but it's not just date of discovery. It's when one was aware or reasonably should have been aware of the wrongdoing. The case was filed 3 years and 3 days after the close of escrow. So in this case, the person you may think is the wrongdoer, right? The seller who did not make the disclosures, moved for summary judgment. Summary judgment was granted because the case was filed too late, 3 days too late. The homeowner said, well, wait a minute, maybe my fraud claim is filed too late, but what about my breach of contract action? Breach of contract, 4 years. And the court said, we don't look at the specific cause of action. We look at basically the gravamen of the complaint, even the breach of contract. The contract says seller will make the disclosures. The seller did not make the disclosures. That all ties back to fraud. We as a court, we're saying the 3-year statute of limitations applies regardless of the specific cause of action. So you guys should be aware of that in our listening audience. Ash, Peter, Frantz, anything?
I can guarantee that attorney is going to be sued for malpractice for missing that statute of limitations issue. I can't believe that they would file 3 days late. That's a big problem.
Yeah, big mistake, right? I agree with you there.
Yeah, but I mean, I don't know. I don't remember exactly seeing how that attorney became aware of the statute of limitations issue, or when the attorney actually contacted the client. But really, I mean, maybe because I'm a lawyer, but like, I feel like a lot of times it's kind of on the clients. They're just like, oh, I have an issue, but I'm not going to deal with it. And then somehow something magically happens that makes it an urgent issue. And then it suddenly becomes our problem as a lawyer or as lawyers to figure out like, oh, okay, well, you have a statute of limitations issue. Like, they clearly said that she had reason to be suspicious and really should have contacted an attorney earlier than, 2014.
Well, I mean, Frantz, before I just go to our CLE stuff, I think you're absolutely right. Again, I don't litigate, but if some client comes to you, you've got to be thinking of these things, because at the very least, you need to put that client on notice at that first meeting, which is, wait a minute, you've got a statute of limitations. It's coming up, in a week, in a month, in a day. And if I'm not going to file for you, I want to put you on notice that you better find somebody who will, right? Otherwise, the burden could be placed on you. As Ashley said, this case may be ripe for a legal malpractice claim.
Yep.
All right, so just really quickly, a bunch of webinars coming up. Hey, if you want to go to one that's going on today, if you think it's ethical to start a webinar a half hour after it's already been going on, well, then go ahead, go to the ethical and effective online marketing one. We got some yoga stuff going on. One that I'm going to participate in a couple of weeks, broker supervision in a paperless environment. And look there, July 28th, California Eviction Moratorium update. And that's going to feature Rachael. I don't know if Rachael is still with us. That's going to feature Rachael, who's going to have a whole hour rather than try to cram everything into 15 minutes.
Mhm.
So.
And that one is free. So there's no MCLE credit, but it's just basically a roundtable update on the moratorium. So it's free to attend.
You know what? And the one right before that is free too. I didn't realize that one is free. Sorry, I did not mark that.
As is the yoga on the 17th and the 31st.
Yes,
and that's going to be great. We have a certified yoga therapist who does both therapy in family situations with yoga, and then also teaches yoga. So there's going to be a lot of really good stuff about mindfulness and meditation and all that.
And cannabis sorry, Frantz, just real quickly, cannabis has been in the news a lot these last few days. It looks like, there may be something going forward on the federal level. Might happen this year. We'll find out. There was a whole cannabis series. The first sessions were at the beginning of July. We got 2 more coming up in August. You want to hear about cannabis and real property? You can come hear me. I'm going to be one of the presenters in that one, but 4 great programs on cannabis coming up in August and in September. And again, if you miss something, you always have an opportunity to hear it later. Frantz, I cut you off. What do you want to say?
Oh, no, I was going to say, and the webinar on July 23rd will feature Ashley and myself. So if you like watching What's Up With Us, then we will also be talking about other things that are entertaining.
Well, I did not know that. Okay, so I'm gonna have to look at my calendar and see. Although I'm not a young lawyer, that's for sure.
I think it's supposed to be for new lawyers, not young lawyers. I think that's a type of renewal.
I'm not a new lawyer either.
You don't qualify for either, yeah.
I guess not. But it's so nice to hear that the 2 of you are going to be presenting. It seems like, having people prepare for their career. It's something that I think attorneys don't get enough of, and it leads to a lot of dissatisfaction when they haven't thought things through. So I'm glad the 2 of you are putting something together for our younger and newer legal professionals.
Yeah.
All right, I see we're right here at 1:30. Again, if anybody who has comments, please write them into us. No problem. You can send anything you want to me, Neil K, NEILK @CAR.org, and we'll see if we can bring that up. Hopefully we'll see you next month, Thursday, August 19th at 12:30. Bye, everybody.
Thanks so much.